Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is November 8th, 2018. This is our bi-weekly community conference call, which we hold every other Thursday at 12:30. Let me just make sure that everybody can hear me okay.
The conference is now in conversation mode.
Can you folks hear me okay, guys? Can you hear me all right?
Yes.
Okay,
Yes.
excellent, excellent, excellent.
The conference is now in presentation mode.
So I'm going to go over the questions first, which I have marked as frequently asked questions. Either I'm getting old or there are a lot of questions that just keep coming up time and time again. I think part of it is the Trump administration, where things that we used to know have become unknown and things that were unknown have become known in some bizarre ways. So let's begin with the impact of unlawful presence. Now, I've covered this issue before. If you go to our frequently asked questions on immigration.com, I have spent a good 10 minutes on describing the difference between being in status, being out of status, being in unlawful presence, and being in authorized period of stay. Each one of these four have a different connotation. I'm going to cover only unlawful presence because those are the two questions, the first two questions, which I marked as frequently asked questions. The first one from George Penn says, I'm a lawful permanent resident for 1 year. I married my wife 10 months ago. She had come on a J1 visa that expired 12 years ago. So the question is, now under the earlier rules, she could stay in the United States, and if she came in legally, which she did, and she had the date of expiration on her I-94 as DS, duration of status, then she could not accrue unlawful presence at all until an immigration judge or USCIS said that you are out of status or unlawfully present. That has changed, as this gentleman knows well, and they have pointed out, under the new memorandum, she will start accumulating unlawful presence on August 9th, 2018. And the way this works is, if you accumulate 180 days of unlawful presence, you will be barred from entering the USA for 3 years. If you accumulate 10 years, then you cannot come back for, if you accumulate 1 year of unlawful presence, then there is a 10-year bar. That's called 310 bar. Now, there is of course a waiver called 212D3 waiver, which is available for non-immigrant visa, but that doesn't help you in your green card. For green card, you have to show extreme and exceptional hardship. There's another kind of waiver to your US citizen or immigrant relative. So it becomes quite complicated. Now, I don't want you to take my word on this. It's definitely worth your time to spend a half hour with a lawyer, go over your wife's situation in detail, learn all the pros and cons of your situation. I don't have time to cover it all here, but I'll give you some broad guidelines. Okay. First of all, remember, an unlawful presence bar is a zero-sum proposition, which means either you have it or you don't. What does that mean? So if you leave USA on 179th day, you have zero consequences for green card. But if you leave on the 180th day or 181st, I forget which is it 180 or 100 over 180, one of the two. Let's say you leave on 181st day. Now you've got a 3-year bar. So just a day or two before you had nothing, and then the date you received that 180-day unlawful presence, you become subject to the bar. So it's all or nothing. In your case, the first thing I want you to do is make sure that she came in on an I-94 that said DS. Because if she did not have DS, then she's been accumulating unlawful presence for a while. And then the only solution is, when you become a US citizen, you can then apply for her I-485 without having an issue with unlawful presence because she entered legally. Okay, so please do spend some time with an immigration lawyer to go over all of this. Press *5 if you have a follow-up question. *5. No new questions? Follow-up question. Okay. The next question is also about unlawful presence, and Manjula said, my son's I-94 and visa expired in June. Now, first of all, looking at your picture, if this is your picture, I'm assuming that your son is a minor. Okay. So for a child under the age of 18, until they hit 18, there is no unlawful presence. They're only out of status. Okay. Once again, unlawful presence problem is only for people who are age 18 or older. So if there's a child who's, for whatever reason, fallen out of status and become unlawfully present and was unlawfully present for 9 years from the age of 2 to 11, no consequences. There's no unlawful presence. Now, one thing, though, is very difficult to predict, that you applied for an extension. I don't know what the status is. Are you applying for an H4 extension? So I am missing some information, but there's no unlawful presence. If you're on the phone, press *5. Press *5. I need some more information from you. Okay, so you're not here. Broadly speaking, if they are under the age of 18, there's no unlawful presence. Would they be able to get extension? I do not know. Next frequently asked question. This is also very common. Vijay Amin says, how can I downgrade from EB2 to EB3 because EB3 gets faster sometimes, and what are the consequences? Now, what we have been doing, and that was something that was suggested a few years back when the situation had presented itself, it's still working for us. That's what we do. If we have an EB2 approved I-140, we apply for an EB3 approval on the same form, or you can file, like you said, you can file EB3, I-140 and 485 concurrently if the dates are current. If the I-140 is denied, the second one that you filed, what are the consequences? Will the 485 be also denied? Of course. If you file a 485 that is prematurely filed when the priority date of EB2 is not current, if EB3 is denied, on which basis you had filed the 485, then the 485 will also be denied. No, my concern would always be this. If you are re-agitating the I-140, are you creating a problem? Because sometimes there can be an issue that nobody noticed that crops up in the second I-140 filing. I would want your lawyers to review your case very carefully. Make sure that you don't have any other issues that are going to become a block, not only for the new I-140 under EB3, but call into question your already approved EB2. If the second EB3 filing, after EB2 you did an EB3 filing, gets denied, it should not have any impact on the already approved I-140 unless the second filing reveals some problem with the case that was not addressed earlier. One example is if your degree was not finished when you filed the PERM application, or you didn't have documentation of experience, something like that can occur. *5 if you have a follow-up question. *5. No new questions, please. Press *5 on your phone. Okay, so we have one question, and this is from Pennsylvania. Yeah, Pennsylvania, go ahead, please.
Hi, Rajiv. In the case of the company has bought some other company like successor of interest, and that time I think we need to refile the 140. I think so. So in that case, say like if I want to downgrade from EB2 to EB3, and then when we file like that, and in that situation if my EB3 is getting denied, so in this situation what will be the consequences?
Okay, you have two sub-questions within this. One sub-question is, when there is a takeover of the corporate assets or company or division, do we have to file a new I-140? The answer is yes. If your I-140 was already approved under the earlier company, in successor in interest cases, USCIS guidance is that you should file a new I-140. The second question is, if I filed the second I-140 under EB3 instead of EB2, and that gets denied or gets into trouble, is that a problem? No, not at all. You can always file it again under EB2. Although, when an EB3, well, there are, again, going over the decision tree. See, I think like a programmer many times. There's a decision tree, there's an algorithm here. So, when we start branching out on the logic, this is how it works. Company takeover. Next step, I file I-140. Next step, it either gets denied or it gets approved. I've done it under EB3. If it gets denied, I would want to know why it was denied. If it was denied for some basic structural fault with my earlier EB2 case, then I've got a problem. The second step in the same hierarchy would be, it is denied for some problem with the documentation of successor in interest, then that's going to be a problem for EB2 as well. So normally an EB3 denial in a successorship case can be a problem only if it reveals some problems either with the structure of the earlier filing or with the documentation about the successorship. So it's a difficult case to give you an opinion on, but that's how it works. So company takeover, file I-140, gets approved, file 485 or file both together. Okay.
So even my first company has filed me in EB2 and I want to downgrade to
Yes.
EB3 and
Yes, you can.
still refile concurrent.
You can.
Okay.
I don't see any need for you to first file an I-140 under EB2, wait for it, get that approved, then file an EB3 to downgrade. I don't see any need for that. I think you can go straight to EB3. Okay?
All right, Rajiv. Thank you very much.
Oh, you're welcome. Okay, next, let's see. So this is another one that's a frequently asked question. I think I've dealt with it several times, but I don't remember. The question is, can I travel while my H4 EAD is pending? And let's address this in two different possible scenarios. Let's say I'm on H1. My spouse is on H1 as well. I want to convert to H4. This actually came up yesterday in the case of a client of ours. Now, she wanted to travel abroad. And I told her, if you travel abroad, your change of status request from H1 to H4 is deemed to be abandoned, and so is your EAD. If, however, you're already on H4 and you applied for an EAD, can you travel? The answer is yes. You can travel if you're already on H4 and just your EAD is pending. So if you have a change of status as well as EAD is pending, don't travel. If only EAD is pending, you're already on H4, that's okay. But USCIS has said that they discourage this practice because it can lead to delays and confusion. I don't see why, but that's what they have said. So you take your pick. Personally, I don't think it's the end of the world if you do travel. *5 if you have a follow-up question. *5. You know, it's interesting. I've been practicing law for almost 30 years, out of which immigration law for about 25, 26 years. And every day I learn something new about immigration law, and the more I learn, the more I realize how complex things are. Everything is connected with everything else. It can be quite confusing even for seasoned people. In our office, typically, unless you have worked between 5 and 7 years, we don't even let people talk with the clients about legal issues, simply because lawyers need time to get seasoned in immigration law. So the next question, just making you aware that things are very complicated. Don't take it for granted. It's a good idea to have somebody take a look at your case in detail if it's complicated or if some major consequences are involved. Next one is from Sandeep. He says about filing change of address. First of all, guys, remember, if you are on any non-immigrant visa or even when you have a green card, every time you move, as I recall, within 10 days, you have to update your address. These days you can do it online, very easy to do. Earlier it used to be filing form AR11. That form is still around, but there's no point in using that. Just do it online, and you are required to do it until you get your naturalization. So if you're on student visa, H1 visa, L1 visa, P visa, any kind of visa, if you move around, you're supposed to inform the government online or by filing AR11. So Sandeep wants to know, should I update since I'm the beneficiary and my wife is a green card holder? Now, since you are living in the United States and you don't have a green card, I'm assuming you're on a non-immigrant visa. You haven't made that clear. If you're on a non-immigrant visa, you have to notify the government, no question about it. If you are working on a short-term contract, I think, because if you intend to live with your wife, I would give your wife's address as the permanent address. And I think that's okay, especially if you're working on short-term projects from place to place. The second question is a little bit off the previous discussion. He wants to know what happens if someone overstays on their visitor's visa and the sponsor is not aware of it. The only thing I would be concerned about is that the sponsor was not involved in any kind of wrongful conduct, something called smuggling aliens. So if they try to assist somebody in entering the USA with the intention to stay here permanently, that's an exposure. But if just a routine visitor comes and overstays, I don't see how the sponsor is responsible under immigration law for anything beyond what they have said on the form I-134 affidavit of support. I don't see any other exposure. Sometimes you don't even file an affidavit of support. Star 5 if you have a follow-up question on this. Okay. Now this is another interesting question. I've dealt with it before. If you go to my frequently asked questions, our YouTube channel, all of this is on our homepage, immigration.com, on the top right. All our social media is there. My Facebook page as well as my Twitter account. So any of that, LinkedIn, you can connect with me and keep track of things. We had done an update on this. If you are on H4, those days there were no EADs, but that question still came up. I'm on H4. What can I do? Can I own a company? So this gentleman, Vinod, says he's got some great ideas, I guess, and he wants to start. He started a company, but they haven't done any business. Now, starting a company, of course, is not illegal. Doing a business while you are still on F1 status is illegal unless you get OPT. If you get OPT, government has set a time or two as long as you're working in your own field. So if you are a software developer or you have a degree in computer science and you start a company where your primary role is software development or something akin to it, then you are allowed to do that as long as you have your OPT. You cannot do that in STEM OPT extension, but you can do it for the 1-year OPT. After that, we've had cases. We had a case from, I believe it was MIT. I'm pretty sure it was MIT, where an inventor got a good seed funding from the university itself, and they have some kind of a program. And we assisted the inventor to set up a company in which he himself got an H1 through his own company. That can be done. There are some restrictions. It's got to be a genuine employment situation. So there's some restrictions, but it can be done. I'm always leery about telling people depend on this procedure because you never know. So without putting all your eggs in one basket, you could certainly work on OPT on your own business, hope that you get picked up on the H1, and if you do get picked up on the H1 lottery, and then of course there is a setup whereby you can work for your own company, and we make it all clear to the government there's no playing games with the government. Okay. Otherwise, if you start business on OPT, that would be illegal. I'm sorry, on F1, that would be illegal. So the only 1 year period while you're on OPT, it's okay to own your own business, provided you are working in your own area of education. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go on to the next frequently asked question. Now this is also frequently asked question. What happens if I don't have a job on AC21? So as you folks, a lot of you do know, I'll just run through the AC21 law for you very quickly. It's good to have it all in one module. So the way it works is, AC21 says, if my I-140 is approved and 485 has been pending 180 days, I can take same or similar job with any employer without having to redo the green card. Now some questions that come up in this context are, number one, do I actually have to be employed with the sponsoring employer for 180 days after the I-140 is approved and 485 pendency? The answer is no. So let's say you filed your I-140, 485 concurrently, and you left 3 days after that. Technically, you don't have to be employed with them as long as the I-140 does get approved and 485 stays pending 180 days. Here's another interesting thing. Let's say you filed your I-140, 485 on January 1st. In March, 90 days later, your I-140 gets approved. Now, do you have to wait 180 days after the I-140 approval? No. Once the I-140 is approved, 485 that has already been pending 90 days, that time is counted and you have to have another 90 days. That's the second thing to remember. Third thing, which is this issue, how about if I'm without a job? My 140 is approved, 485 has been pending 180 days, and I didn't feel like working. I wanted to chill out at home and watch cricket or soap operas or whatever I feel like doing. Does that cause a problem for my green card? And the answer is no, as long as when you get an RFE from the government, you either already have a same or similar job or you can provide a same or similar job offer. So having a gap in your employment after you have qualified for AC21 or while you are still qualifying for AC21 is not a problem. Okay. Star 5 if you have a follow-up question on this. Star 5. Next question is about naturalization. Well, I want you to be aware of something. Government has become very odd and strange about naturalization applications. Many of them are going through without any problem. But imagine that in 26 years, I had only gone to any kind of interviews or appeals at the USCIS level maybe 3 or 4 times in 26 years. But in the last 4 or 5 months, I've gone for regular routine interviews, non-routine substantively, but procedurally routine, because why would I go for an adjustment of status interview? You shouldn't need a lawyer. That's a simple process. But they've been digging out information from 14, 15 years ago in naturalization, adjustment of status cases. So please be mindful of that. They have been digging out information from years ago. Okay. And you do need a lawyer in some of these cases because things can get tricky. The laws are complicated. Even many times the USCIS officers themselves don't know what the law is. Some of the senior ones who are well trained are of course very, very good at it, but what is the guarantee that you will get somebody seasoned? Okay. So with that said, now here is a situation. Anup GC says, and he raises some very interesting questions, and I wish I had time to deal with all of them because it's not really his question. But he's made an observation. What is the question number we are on? We are on number 10. Well, I'd have time to a couple of minutes to talk about this. I want to talk about it. It's an interesting issue. So the issue is, let's say you are working for a software manufacturing company. Let's say you're working for Norton antivirus, Norton company, and you're working in-house for them. You help develop the antivirus software. You are a C wizard, and you do your work with them. Now, we know that's a full-time permanent job because you're working in one location. They have a job for you. What about consulting companies, where you could be working 3 months here, 6 months there, 8 months there? Well, the answer is that's okay. Even that's considered to be a permanent job, because even though you don't have one seat, you do have a job based upon a course of conduct which the employer has been in business and doing for a while. So it's a fiction created by law and accepted, because remember, when these laws were written, government was not ready for the service economy. Service economy always has situations where you have short-term projects, all service-based work, and this is a normal situation. So I'm not worried about that part, but you have some good points. Just remember that as a theoretical framework. So then I want to address the situation generically. Let us say that I'm working for a company. Let's just call it IBM. Okay, I'm working for IBM, and IBM applied for my green card. Somewhere along the line, I left IBM and I went to work for some other company. Okay, my green card got approved. I never joined IBM back again. Is my naturalization in trouble? Second scenario is I'm working for Sun Microsystems. IBM loves me. They start my green card. They are going to do it as a future employer. They process my green card. It's completed, but I never joined them. Is that okay? So the answer to these questions depends upon a few factors. First of all, remember, the laws have changed. I think it's from 2017 or 2016 that they started Supplement J. Now Supplement J has become an issue. Previously, when you did an AC-21 shift of jobs, there were no filings required. So in older cases, even if you don't join the employer, chances are you're in pretty good shape. Now, I do want you to take a consultation. I want you to spend 15-20 minutes with a lawyer, go over your situation, make sure that there's nothing else here that's going to be bothersome. Okay? Another thing that I always consider to be important, and it often doesn't come up, it involves your state of mind. And state of mind being inside your head cannot be excavated. Nobody can get into your mind and dig out what is in there. They can only ask you questions and look at your conduct. What do I mean by state of mind? Green card is based upon an intention of an employee to join an employer on a permanent full-time basis, either before or after the approval of the green card. That's why even though I'm working with Sun Microsystems, my green card was filed by IBM and it even got approved through IBM, but I never joined them. As long as when I first filed the I-140 and first filed the 485, it was my intention to join them. Later on, if I did not, under the old rules, it wouldn't be a problem. Under the new rules, Supplement J would be required and government asks for it. Okay. So what I want you to do, sir, I'm trying to see who it was. Anup GC. I would want you to talk with a lawyer, go over your case specifically. Let's make sure that you don't have any other ancillary issues. Sometimes they do come up. So have that discussion and then go in for your naturalization. Okay. Star 5 if you have a follow-up question. Star 5. Yeah, you have this questions about what kind of documentation to produce, etc., etc. Get this into a consultation. Have somebody focus just on your case and talk to you about it. Look at some of the paperwork. ask you questions in a give and take format. Okay, do that. Next question is, and this is something I want to talk to you about, guys. This is quite alarming. And I just did a consultation day before yesterday on a situation. We've not had this situation come up, but I'm sure it's going to happen to our clients too. Government is saying that you cannot have more than 12 months of CPT and OPT combined at one education level. Let me give you further details on what that means. So let's say I am doing my bachelor's degree in computer science and I have taken 6 months of CPT, curricular practical training. Government says now I have only 6 months of OPT left. If I have taken 12 months of OPT, I don't have any CPT left. Next example is I took my 12 months of OPT. When I go for master's, I've got again those 12 months because I went one step up in my education. I would have that again in PhD. Every time I go one step above, I get both OPT, CPT combined 12 months, and I can get STEM extension for 2 years for each additional educational level. But here is a situation that comes up. I've got master's degree in computer science, and now I'm doing my MBA. I don't get another shot at CPT, OPT if I've exhausted 1 year or 1 + 2, 3 years for STEM extensions. Why? Because master's in computer science, master's in business administration is the same level, master's level. So keep this in mind. What is more bothersome is, are they going to start applying unlawful presence on people who have exhausted more than 12 months? Because we were doing that. We didn't have any problem with that. You could get CPT for any amount of time. You won't get OPT if you have exhausted 12 months of CPT. But getting CPT after 12 months of OPT was never an issue at the same level for a different degree. So I think they're going to get sued on this. I'll be surprised if they don't. Okay, that said, let's look at Surya's questions. August 9 unlawful presence rule applies to my case if I get a response for RFE after Feb 4th that completes. Okay. In case if H1 is approved but change of status is denied, will my F1 visa be still active until I get H1 visa stamped? Okay. So let's look at that scenario. I think I understand what you're asking. Let's look at this scenario. I filed my F1 to H1 change of status. My OPT is good for another year. Let's say I got my STEM OPT. My OPT is good for another year. My H1 was approved, but my change of status was denied. I'm still on OPT. My OPT is not gone anywhere because I never got the change of status. However, you do need to contact the school and make sure they don't cancel your service. They often do that. But if you have not received change of status, in my view, and I've not seen anything different from the government, in my view, you are still on OPT. And to activate your H1, you have to either refile for change of status or go outside USA for visa stamping. Next question, I'm planning to do PhD after completion of my master's program. Will CPT that I use during master's affect my future immigration chances? And the answer is no. I just went over all of that. Okay, I think I've covered all the issues here. *5 if you have a follow-up question. Press *5 on your telephone if you have a follow-up question on these issues. Okay. All right, let's go on to the next question. Oh, this is not a frequently asked question. I'm just doing the frequently asked questions first. Okay. Oh, I think we just went over this. Fraud implications for naturalization. I did not work for the green card company. Okay, let's look at this situation real quickly. I think he left me a message that look at question number 19, not 18. Today I had a little time, so I was able to read. Please ignore post 18 above and replace it with post 19. Yeah, I think that's the post that he wants me to read. Clear signal. completed masters in 2001, 2004, employer A H1B, 2008, filed for green card in EB2 through the same employer, moved to India to run Indian operations for company A, converted green card processing to consular processing, then got my immigrant visa in 2013, entered USA for a short 1-week visit and received green card, continued running India operations. Then in 2014 came back. Now this is a difficult situation. You should definitely take a lawyer with you. Okay, I would argue that this is fine because once you went and got your green card, you took the job and you're just working for the company's operations outside USA temporarily. So I think it's going to be a touch and go, but that's what I would argue. You definitely need to take a lawyer with you. I don't think this is an easy yes and no problem kind of situation. Okay, I don't think you have a clear-cut no and you don't have a clear-cut yes. *5 if you have a follow-up question on this. *5. Okay, let's go over the non-frequently asked questions. And then if time permits, we have about 25 minutes to today's call. If time permits, I'll answer any questions you folks have, okay? So all of these were fact. We've done these. Filing change of address, starting business on student visa. Okay, Nick Agarwal says, my wife went to give L1B blanket interview, got denied. Appeared for H4, got denied. Reason was she was traveling to a different city than her husband. Well, that is no ground for denial. You need to agitate that with the consulate. Get a lawyer, get them to write to the consulate and lay down the law for them. Where the heck does it say that you've got to live in the same city? Career couples often live in different cities. Often. Very, very common. Now I was laid off recently. New employer has filed for the H1B transfer. Waiting for the transfer. My wife is suggesting to go for No. Don't go for an H4 visa interview again until your transfer is actually approved. Don't go for that. Consulates are not going to approve that case easily. I would be surprised, especially with this history. So they'll probably give it some extra love, some extra scrutiny. So I would suggest don't apply for an H4 just now. Go ahead and get your H1B transfer done, then apply for your H4 visa. But if you have lawyers helping you, it doesn't hurt to reach out to the consulate and say, look, he's maintaining status. You should be able to give me my H4. She's tied into him. He's maintaining status. Doesn't hurt to ask them. I usually would just reach out to the consulate, see what they suggest. *5 if you have a follow-up question. *5. Okay. I'm going on to the next non-frequently asked question. So the question is, I'm marrying a lawful permanent resident. She just received her green card a few months back through family-based process. She's planning to find a job in the USA after marriage. How quickly can she sponsor me for green card as the spouse of a green card holder? And the answer is, the day she gets her green card approval, she can file for you. Is it necessary to be in a job? Well, you'll need a co-sponsor. So she'll have to give her affidavit of support even if she's making zero money. Then you have to have a second person co-apply. Under the old rules, which are still in existence, anybody, a family friend, a cousin, her parents, anybody can be a co-sponsor as long as they are a US citizen or a green card holder. Can her father jointly sponsor me? Absolutely. What is the best way for me to come to USA? H1, L1, O1, these types of visas which are dual intent visas. *5 if you have a follow-up question on this. *5. Okay, this one is coming from overseas. Yeah, go ahead, sir. Go ahead.
Yeah, hi Rajiv. Thanks for your information.
Of course.
I have just a follow-up question on 17th question, I think.
17th.
I think after that I'll just...
But I'm not even on 17th yet. Oh, is that a frequently asked question? 1 second.
So it is not.
17th, 18. But 17th, I haven't Rajiv Sharma or continuation of the 12th message.
Same.
Oh yeah, I see. Oh, you have
It's
another
continuous.
part here. I see. So you have two questions that are connected, but they were put in separately. Okay. Then your continuation of the 12th message. Get married after my marriage. My wife goes to USA, files for me. AOS will be provided by, no, there's no AOS. You are outside USA. No, I don't see how you would file adjustment of status. You cannot file adjustment of status unless you are in USA on an appropriate visa. So go ahead. I understand what you're asking me. What is your question now?
Yeah, it's affidavit of support, Rajiv, actually.
Yeah, anybody can file affidavit of support as long as they are green card holder, US citizen, and domiciled in the USA. Anybody can file.
Okay. Somewhere I saw like the address of the green card, the spouse who is sponsoring me should be same of the one who is sponsoring.
No,
Is that true?
there is no such requirement that the address of the green card sponsoring spouse and the affidavit of support giving friend or family member should be the same. No, not at all.
Okay. Continuing with that. Another question is like, I have saw like if she is not earning anything, and considering the other case like her father also don't meet the expected financial support. So in case one of my cousin, so not her cousin,
That's
who
okay.
sponsors
That's okay as well, sir.
jointly with her.
I've already covered that. Anybody can be a sponsor, affidavit support sponsor. Anybody. Okay.
No, yeah, that's fine. But I have seen like the one who is financially giving the support will become the primary sponsor, something like that. Is that true?
No, they are responsible for you. They are responsible if you take any kind of means tested benefits or prohibited benefits, the government can sue them and recover the money from them.
Okay.
All right.
And the final one.
Good luck, sir.
Thank you. The final one is like.
Okay. Very good.
Rajiv,
Sir, I gotta go on.
the final one.
Yeah, good luck.
Like,
sir, I gotta go on.
Sorry.
Okay. I got other questions waiting. I gotta go on. Okay. Yeah. So guys, you gotta be mindful of other people's time also. Post it. If you have questions, post them. Don't mind spending 1 or 2 minutes in a conversation, but I can't spend a lot of time. Okay, so next question is Krishna 3 check. We went to India in June 2016 when my wife was on F1 status. While coming back to the USA, she had H4 stamped at the consulate. At Abu Dhabi port of entry, they gave her a form. I'm not sure I understand what is going on here. Application for waiver of passport and or visa. They cancelled her H4 visa and issued F1 again. That makes no sense. Yeah, I don't see how this can happen, Krishnaji. This makes absolutely no sense to me. If you're on the phone, press *5. This makes no sense. Yeah, let's talk to you. So, California, I presume. Yeah. Let's just... Okay. Yeah, go ahead, sir. This doesn't make any sense to me. I'll tell you why it doesn't make sense. So, she can get an F1 stamped or reinstated. I don't know how they can even do that. Only if she was a full-time student. When she was coming back, was she a full-time student?
Yeah, during F1 she is full-time student.
No, I'm talking about June 2016. So in June 2016, when you guys left and came back at that time, she was still on student status?
Yeah, before going to India, she's on F1 status.
Okay.
And in India, like, we have gone to H1, my H1 stamping and my wife's H4 stamping.
Right.
And at port of entry, we were caught, and at port of entry, they told that you cannot enter on H4. You should have F1 status. I mean F1 visa.
Was she still?
The reason
hang on,
is
hang on,
whatever
hang on,
this
hang on. Was she still going to school?
she's already completed.
Yeah, they can't.
and
That was an illegal act. I don't see how they can do that. So now, what I think you should.
Yeah. The reason is
Yeah.
no. Here I'm sorry. I have missed one point. When before going to India, she changed from H4 to F1. She had just change of status. So they mentioned that when you change the status in US, you should get that stamping rather than new stamping.
No, that's incorrect. That's your choice. You can get whatever stamping you want. This was somebody who did not understand.
Okay, now
Hang on. This was somebody who did not understand the law at all. Okay, unless there is something else here we don't know about, this is an absolutely illegal conversion. They can't do that.
Okay, now my doubt is right now, I mean, my employer has filed my H1 extension and my wife change of status from F1 to H4 again. So, I mean, will there be any chance of getting RFPA because of this port of entry, conversation?
This should be taken care of. Your lawyers should have you go to the Customs and Border Protection, get the I-94 and the class of admission corrected. This was an incorrect class of admission. She shouldn't have been made to enter on this. Only then file for her H4 extension. An H4 extension should be filed because she's not been maintaining status. If they give her F1, of course she's not a student, right? After she entered, she's not been maintaining status, correct?
No. After coming to US, she went to college again.
Okay, your narrative.
She went to college.
Your narrative is very confusing.
She got divorced.
Your narrative is very confusing. Okay, because I asked you, I said in June when you entered, was she still in school? You said no, and now you're saying she went back to college. I don't understand this. Let's take a step back, and I only have about a minute more to spend with you before I go on to the next call, next message. I just have a simple question. When she left the United States before June 2016, she was on F1 status?
Yes.
And she was going to school full time?
Yes.
Okay. You went to India. You went and applied for her H4 visa stamping, correct?
Yes.
Okay. She had an earlier F1 visa stamped on her passport already?
No, it's a change of status from H4 to F1.
So when she had entered USA the first time around, she had entered on H4?
Yes.
Then she changed status to F1. Then you went and got an H4 visa stamping again?
Yes.
Okay. They should not have converted her back to F1. But was her F1 visa still valid when you entered USA at that time?
Sorry.
When you entered USA, the visa stamp on her passport, did she have a valid F1 visa stamp?
No. She had just change of status. There is no F1 visa stamping on her passport.
So
it's
I
a change of
think
status.
I don't have enough time to go over the details. It looks wrong to me. Something is not right in this situation. Either CBP has made an error, or I am not following something here. Some mystery that I don't understand. This whole narrative looks wrong to me. What I want you to do is this. Go to your lawyers, explain the situation to them, see if they advised you to go meet up with Customs and Border Protection. Because this can become problematic, Krishnaji. I don't think it is problematic, but it can become problematic. So you want to fix it. Go ahead and talk with your lawyers.
Okay.
See if they want you to go to CBP, talk with CBP, explain to them what happened, let them look at their records. Let's see if they can correct this. Something is not right here. This is not a normal process.
Okay.
Okay?
Sure. Yeah, I will do that.
Good luck, sir. Okay. So then next question is Andy T. Guys, I'm not going to have time for new questions. I wanted to, but I don't have time. We have about 11 minutes left to this call. Andy T says, I got my employment-based green card 4 months ago. 1 month after getting the green card, I started my own IT consulting company, started working on additional projects. After 4 months, I would like to quit. And I think that's okay. I don't see why not. Because what is the law that says you've got to work with this company after getting a green card for X number of months or years? There's no such law. Personally, I think that's okay, as long as on the date you got your green card approval, you had no intention to quit them within a certain period of time. So if you had the intention to continue working there indefinitely, when you got your green card, great. But if a month later some opportunities came up and you wanted to start your own company, I think that's perfectly fine. The critical point is the date you got your green card approval. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay. Abhijit says, I'm working in Bengaluru and I was on H1B from 2006 to 2008 for employer A. I-140 is approved. Now I have a job offer from employer C in Seattle. Can I use my H1B from 2006 with an approved form I-140, renew the expired H1B and start my job? And the answer is, I don't know. There are a couple of points where the regulations intersect, and I would want to read the regulations, read the comments from the government on the regulations before giving you a definite opinion. Normally what happens is, if your H1 was approved within the last 6 years, you are not subject to the quota. Your H1 was approved more than 6 years ago. Okay. But you still have time left from the original filing. So what could you do? You could take advantage of something called the remainder option, which says, look, I only used 2 years of my H1. I am okay with only getting remaining 4 years. So approve my H1B without quota issue. I think you will be okay. So you come to USA, but how does remainder option interact with approval more than 6 years ago? I do not know the answer to that question. So once you come to USA, you can keep getting extensions beyond 3, 4 and any number of years as long as you've got your I-140 approval. So the question really, the key tricky question is, if you take the remainder option, which is taking the 4 years remaining on your original H1, can you take advantage of that even though the approval was more than 6 years ago? And I have to look at the regulations. I don't know, but something your lawyers can do. Okay. I won't be able to answer any follow-up question on this because I've said everything I want to. Nevertheless, if you have any ancillary questions, I can try to answer them. Star 5 if you have a connected issue. Okay. So once again, my advice is have your lawyers look at the regulations, and if they are not sure, just file the darn thing, see what happens. Okay. Rajiv Sharma says, I'm on H1B, my I-140 was approved, waiting for priority date 2013. Son is aging out in 2021. Will CSPA help him? Okay, this is how CSPA works. For employment-based I-140s, the time your I-140 was pending is deducted from his age. So if it took the government 8 months to approve your I-140, your son has a deadline of 21 years and 8 months. If the 485 is filed within that much time, he's okay, even if he turns 21 during the pendency of the 485. Okay, your I-140 was pending only 13 days. That's all the grace you get. So your race is to file the 485 by 2021. Star 5 if you have a follow-up question. Star 5. Okay. 12th we have already dealt with. Then the last question for the day. Yeah, here it is. Last question of the day is Pankaj Kulkarni. I'm on H1B currently in the USA. Petition and visa have expired November 6th. November 1st extension had been filed. Spouse and kid are in India. Want them to come on H4. Can I apply for H4 while the extension is in progress? I don't think so. To the best of my knowledge, no. How can I get them here as early as possible? I think you have to wait for your H1 approval. Premium processing is probably going to be available in February. Before that, premium is only available if your H1B extension is without any change. Doesn't hurt to ask for a tourist visa. Government could deny it, consulate could deny it, as long as you make the facts known to the consulate and they still decide to give you an approval of a tourist visa, you can go for it. Okay, that finishes our questions for the day. I have about 6 minutes. I'll try to answer as many as I can. *5 if you have any question. Press *5 if you have any question. So I've got 2 questions, 3 questions. Okay, so that's pretty much it, guys. I'll try to answer these 3 questions as best as I can. So let's go to Scranton, Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
How about the H4 EAD? Any idea? Still continue or anything?
Yeah,
came
they are planning to publish the proposed regulations this month. So I don't know where that's gonna go, but they're supposed to publish proposed regulations canceling out the H4 EAD this month. It'll take them a few months to get this into action, but supposed to get the proposed regulations this month. Okay.
So any public can comment on it?
Of course. Once they put down the regulations, in fact, the more people comment, the better it is, because they have to go through all the comments. Last time there was a major change, there were like 80,000 comments. It took the government 7 months to go over the comments.
Oh, okay. So once, can you please send us the link where we can comment on it?
Once I have the regulations, follow me on Twitter, Facebook, LinkedIn, any of these social media sites. I'm pretty active on Twitter. I'm pretty active on Facebook. I'm very active on LinkedIn. So just follow me. I will post the link for all of you guys. Okay?
Thank you, Rajiv.
You're welcome. Good luck. Okay, let's go to Canada. Canada, go ahead, please. Canada.
Hello, sir. Happy Diwali.
Happy Diwali, sir. How are you?
Good, sir. I have one quick question. My I-140 is approved and my file transfer for CP processing, and I fill it out DS-260.
Okay.
Now is the company which one is file our green card petition is about to sell somebody new owner.
Okay.
Now this case, what happened in my file, sir?
Well, you will keep your priority date. You will keep your right to extend your H1 beyond 6 years through any employer. But
I'm in Canada right now.
Yeah, that's
sir.
okay. But if your new company is a successor in interest, then they have to file a new I-140 for you to continue the green card. The green card can continue only if the new company is successor in interest. Okay.
Okay. Otherwise, they move the location different, same company. Then what going to happen?
If it is in the same city or within 40-50 miles, no problem. More than that, you have to start your green card through another employer.
All over again, sir?
All over again. But you'll have the same.
Okay.
Your
one
priority date will be the same.
Priority date same, sir.
Yep.
If within same, we cannot do AC-21 or something?
No, AC-21 is not available in consular processing, only for 485.
My 485 is denied due to I done consular processing.
You can't do AC-21. Okay.
Okay, sir.
Good luck.
And sir, I have one question. I have DS-260, some error inside form. How I can correct it?
Contact the consulate. I gotta go to the next question. There is a procedure.
Okay,
Actually,
okay,
you can
thank
go to
you.
the frequently asked questions on Department of State website. They tell you how to do that. Okay.
Okay, sir.
Right,
Thank you.
good luck.
Bye.
Okay, last question for the day, guys. Then I gotta go. This one is coming from Texas. Texas, go ahead, please. Texas.
Yeah, hi. Hi, this is Hemant Rajiv.
Yes, sir.
I have a question on my 140 was approved during the 2000 2, and then the employer, I was not working for the employer, he has replaced and he has given it to some other employee, and so right now I wanted to utilize that priority
You can't.
date.
You can't. That's done. If under the old rules, if somebody else used your POM application, if there was a substitution done, you don't get any benefit out of that.
Okay, because that time there was no POM 2000.
Yeah,
Just
it doesn't matter. It was POM in those days. It was called something else. RIR, reduction in recruitment. Doesn't matter. Same thing.
So I cannot use that priority date.
To the best of my knowledge, no, sir. Okay.
Okay, I was trying to. So okay, and actually, if I have I-140 approved in EB1, and I'm not working for that employer right now, so I can still, I got a copy of I-140 original.
Now, was it an EB1A, EB1B, or EB1C?
EB1.
1A, B, or C?
One. I think it is the employment immigration, something employment.
No, they are all employment. Category. EB means employment based. Were you extraordinary? Were you professor or research, or were you an international manager?
International manager.
Yeah, you can't. Unless you filed 485, you don't get any advantage of that. You just get the priority date. Nothing
You can't.
else. Yeah.
Okay, but I can still apply, and if I get a support from them later or something, that's fine.
Well, it's a long discussion, and I'm out of time. Discuss it with your lawyers. Okay. There are a couple of reasons I think this will be a bad idea unless properly looked at. I don't want you to get caught in fraud. You should have the intention to join them. They should have the intention to hire you back. And that's all I can say for now. But do discuss it with your lawyers. It could be a possibility, but you need to understand what you're doing, okay? Good luck, sir.
Okay, okay, thank you.
Yep. Okay, folks, sorry, the time has, I have only an hour. That's why I encourage people to post all their questions online. That way I make sure that I get them all. Folks, it's always a great pleasure and a delight to talk with all of you. And I'll see you again in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.